Good afternoon, everyone. Thank you for joining us for another Beale & Co webinar as part of our regular construction law updates. My name is Will Buckby and I am a partner at Beale & Co. I am joined by Nadir Hasan, an excellent associate in our construction group. This webinar on COVID-19 or coronavirus requires little or no introduction. As you all know, COVID-19 has now impacted every aspect of life in the UK and around the world. This webinar will give the construction sector our perspective on the present position in light of current government policy and what we're seeing and have seen in the market and from our clients over the past several weeks. We have over 500 people attending today from across the globe in the UK, Ireland, the Middle East, where we have offices, as well as continental Europe, Africa, America, and the Far East. The interest in this webinar and the attendees today speaks for itself. We aim to speak for just over an hour today, which is slightly longer than the 1 hour stated in the invitation. We'll first discuss the effects that the disease has already had and will continue to have on the construction sector. We'll look at its impact on projects and on the market. We'll discuss key contractual mechanisms relevant in the present circumstance, notice provisions and the importance for everyone, contractors and consultants alike, to operate the contract, and we will keep coming back to that. We'll look briefly at issues under the relatively straightforward RIBA and ACE consultants appointments, and we'll then move on to focusing on more complex construction contracts and consultancy appointments, including FIDIC, NEC and JCT. We will look at administration duties, such as those required of a contract administrator or service manager. We will consider how contractors and consultants can best try and protect themselves to mitigate the impacts of the virus, looking first at notice and update requirements, and then at entitlements to extensions of time and additional cost. We'll briefly consider the extent to which you may be able to rely on COVID-19 and its effects constituting an event of force majeure, both contractually and at common law. We'll wrap up by running through the steps that we think you should be taking on your projects, and we will advise on a sensible way forward in light of the current position, particularly in respect of site work. Do you remain on site or not? We want to give some conclusions. We are delivering this webinar from an English and common law perspective, although many of the principles we discussed today are equally applicable in jurisdictions across the world. That said, our offices in Ireland and the Middle East will also be delivering webinars on COVID-19, building on what we've said today. And we have details on the last slide. And finally, we're focusing on here and now, and the steps need to be taken now as a result of the disease. Clearly, there will be matters to consider in future weeks around the likes of payment and outstanding fees, issues arising on delayed or stalled projects, insurance, positioning oneself for transitioning back to work, and amongst other things. We will be delivering a webinar on this also. COVID-19 has now had a fundamental impact on every business in the country. No matter what sector you are in, the first and foremost duty of all businesses should be and will be to ensure the health and safety and well-being of employees. Employers must have regard to their duty under the Health and Safety at Work Act and associated legislation to protect the health, safety and welfare at work of their workforce, as well as others who may be affected by their operations. Employers must have regard to their common law duty to take reasonable care for the health and safety of their workforce. They must have regard to the express and implied terms of contracts of employment and other contracts for the personal performance of work or services, including the implied duty of trust and confidence. And they must also have regard to the duty under the Equality Act not to discriminate against employees or workers with protected characteristics. This must include a duty to take those reasonable steps to avoid employees at work being exposed to or infected by COVID-19, or supporting anyone who may have been exposed to or infected by the disease. And you must prevent the disease from spreading through your workforce. The real game changer in the UK was on Monday, the 23rd of March, when the Prime Minister followed the decision made by other countries by ordering a lockdown of the UK, banning all non-essential travel for non-key workers. That means that if your staff can work at home, they must. Clearly, this will be more feasible for some businesses than others. Architects and engineers in design roles, for example, should be able to carry out most of their duties remotely. However, this won't be the case if you're a contractor or an engineer with a site role. No matter how well equipped your home office is, it simply won't be possible for you to work remotely. We will look in a minute at project sites, whether or not these should remain open. The next question is whether you should keep your offices open. If your employees can remotely work, then they should do so. If they can't, and you decide that your offices should stay open, then you should ensure that you take measures to reduce risks for your staff and for visitors. Minimize the number of people in your offices at any one time and their contact with each other, and hold meetings by telephone or video conference. Follow recommendations from Public Health England. And if you do keep your offices open, ensure that you keep up to date with government guidance. This, as we know, changes daily or sometimes more often. Project sites. Some employers have closed their project sites. Crossrail and Transport for England, for example, all closed their sites early last week. In other instances, contractors have suspended work and closed their sites. ISG, for example, announced last week that it would start closing its sites. And Mace announced a temporary 48-hour closure, which has subsequently been extended. However, a large number of project sites remain open. At this time, the government has not mandated a closure of construction sites. It is not at all clear whether construction personnel fall within the government prohibition of non-essential travel for non-key workers. The Secretary of State for Housing announced on Wednesday that if you are working on site, you should continue to do so. The tweet is on the slide. As a result, this leaves wide open the question of whether it is appropriate for you to carry on working on sites that are open. This is, of course, a much bigger issue for contractors and anyone with a site presence than it is for designers. In our view, the present government position means that work on essential projects, such as hospitals, should continue. that work on other projects should continue if government guidance can be followed and the health and safety of employees can be assured. And that in other circumstances, work must cease. To repeat, essential projects continue, other projects should continue if government guidance can be followed and health and safety assured. If you do close, you'll need to make a very careful assessment of your rights and obligations. We'll come on to discussing these later and conclude with a suggested way forward. If your project site remains open and if you are carrying on working, then you and your staff will need to take protective measures, clearly. This means following government and industry guidance. As many of you will know, the Construction Leadership Council published last week a helpful guidance note on site operating procedures. This reminds those involved that, and I quote, the health and safety requirements of any construction activity must not be compromised at this time. If an activity cannot be undertaken safely due to a lack of suitably qualified personnel being available or social distancing being implemented, it should not take place. Chair Andy Mitchell said, whilst the guidance from Public Health England may change in the future, for the time being, construction sites of any size that are operating during the coronavirus COVID-19 pandemic need to ensure they are protecting their workforce and minimising the risk of spread of infection. The guidance covers issues such as self-isolation, travel to site access procedures, hygiene, facilities, and close working, the 2-metre rule we keep hearing about. There is other government guidance that is relevant, including guidance from Public Health England. In addition, there are daily pronouncements from the Prime Minister or the Cabinet that may have a direct impact on your projects. You must ensure that all of your employees and, to the extent that you are able, your supply chain, implement and abide by these measures. This represents the best chance of keeping your personnel safe if they are working on site. To say something positive, we can't forget the March 2020 budget, which took place in the backdrop of the outbreak of COVID-19. For our sector, it was a bold and exciting one. For example, around £640 billion of growth capital investment will be provided for roads, railways, communication, schools, hospitals, and power networks across the UK by 2024 to 2025. However, it is far too early to be able to assess the full impact of COVID-19 on the market. But clearly, we can say with certainty that it will be very significant indeed. Employers will be seeing hugely reduced short-term demand and very uncertain medium and long-term prospects. For example, the immediate market for residential and commercial property has been affected in a very substantial way, as individuals and businesses will not want to commit to any non-essential expenditure until the disruption caused by COVID-19 subsides. This could take some time. There is a real risk of employers becoming insolvent, particularly employer entities that are SPVs set up to develop a particular project. Even if they do not go insolvent, they are likely to review their projects. As a result of this, we could see new and existing developments placed on hold. We might see projects downsize in terms of size or specification to make them more economical, or projects made more flexible to appeal to whatever market segment has the greatest appetite when an eventual recovery begins. Funders will also be impacted. Capital markets have almost completely seized up, with liquidity and risk appetite at an all-time low. The prospect of funders being willing to commit to financing new projects or refinancing existing projects is uncertain. There is the real risk of employers failing to meet conditions precedent for funding and breaching financial covenants. This means that new projects where funding has not been drawn down may not commence for now. It also means that existing projects with funding provided in stages may not progress. Funders may also exercise step-in rights to take over projects from employers. For projects that are ongoing, delays will be almost inevitable. There's likely to be a shortage of labour. Site personnel who have been infected by COVID-19 obviously won't be able to work. But more widely, anyone who has been exposed to or thinks that they may have been exposed to the disease will have to self-isolate and won't be able to attend site. Over and above that, restrictions on travel will discourage staff from attending site, and the significant reductions in public transport may make it impossible for those that want to attend to do so. Where staff do continue to work on site, complying with industry and government guidance will slow down any works. Talking to our contractor clients, this is actually having a significant effect. For example, the Construction Leadership Council's guidance note recommends maintaining a distance of 2 meters between personnel, avoiding the use of lifts, hoists, staggering start times, and avoiding all on-site meetings. This has to have an impact on efficiency and progress on site. Even on projects where it is practical to follow this guidance to the letter, it will lead to inefficient working, which will in turn cause delay. There is also likely to be a shortage of materials, plant and equipment. All global supply chains have been significantly disrupted, and the supply chains on your projects will be no exception. Manufacturers and suppliers will be affected by COVID-19. Factories and warehouses will operate under capacity or may close altogether. Transportation will be affected. Even when materials, plant and equipment can be procured, its transportation to site is likely to be affected, and this will delay deliveries. All of this will cause delay, and as mentioned, sites may well be shut down completely. We will look later at whether you, as a consultant or a contractor, are entitled to claim an extension of time and what you should do about it. Allied to delay is always additional cost. For ongoing projects, cost overruns will certainly follow. There will be cost caused directly by the delay. Contractors and consultant personnel with site roles will simply be on site for longer, whether because the works take longer or because the site has been wholly or partially shut down for periods of time, and more time is needed to mobilise and demobilise and carry on the work. There could also be cost increases caused by shortages. As just mentioned, materials, plant and equipment may be difficult to obtain. Transportation may be limited, and all of this will drive up prices. There will be a need to use what is available, and this will likely impact on the specifications for your projects. Finally, there will be cost increases driven by changes caused by COVID-19. The easiest changes to point to will be in methods of working. Most designers, as discussed, will be able to work at home and meetings take place by telephone or video conference. But this will be less efficient than working in the office, face-to-face meetings, co-locating, and this will have a cost impact. Changes in the methods of working for site personnel will probably be more significant. As I pointed out on the last slide, following government and industry guidance will cause delays and inefficiencies. The other set of changes driving additional cost will be to project specifications. I've mentioned a few circumstances where specifications might change. Projects might be scaled back or value engineered due to decreasing demand, or materials may be unavailable and need to be substituted at the last minute. All of these may save money for the project as a whole, but if you're a consultant or a contractor, they may very well cause you to incur additional cost and expense. We will look later on in this webinar at whether you can claim additional costs and expense, and if so, how you should do so. As a contractor or a consultant, you must be concerned both about recovering additional costs and expense that you incur, and potentially, far more significantly, avoiding liquidated damages and other claims from employers and others up the supply chain. In order to do so, it's essential that you operate your contract. We as lawyers always say this, of course, but in these times, the contract is really the heart of your obligations and your entitlements, and that's what we'll discuss next. Now for some advice on steps to take in these circumstances. All major standard form construction contracts and a significant proportion of standard form consultancy appointments contain obligations either to give notice to your employer in certain circumstances, such as delays to your work or incurring additional costs and expenses, or to make claims. Often, there will be a certain period of time within which you must give the notice or make the claim after you became aware of the events giving rise to it. Sometimes, giving notice or making a claim will be a condition precedent to any entitlement that you may have to relief. In other words, if you fail to give notice or make a claim, and to do so within the timescales prescribed, you will not be entitled to any relief whatsoever, whether an extension of time, additional payment, or anything else. Clearly, this is absolutely essential to get right in the COVID-19 circumstances we face ourselves in. You absolutely must give notice in accordance with your contracts and appointments. The precise stage at which you are required to notify your employer will vary depending on the exact wording of your contract. So will the detail that you need to give and the updates that you'll need to provide subsequently. Nadir will consider the wording in the major standard forms over the next few slides, but given the drastic consequences of failing to do so, if in doubt, notify. This is at the heart of much advice we are currently giving to clients as a result of COVID-19. And in our view, it is necessary to take legal advice on your projects, and many of our clients are doing so. All major standard form construction contracts are detailed and procedural. They all contain mechanisms that the parties need to operate. For this reason, the sections of this webinar that deal with construction contracts, building contracts, aren't just relevant to contractors, they're really important for consultants also. Most construction contracts are to be administered by consultants. FIDIC contracts are administered by the engineer. NEC, ECC contracts by the project manager. JCT contracts by the architect, contract administrator. Even the NEC4 PSC, a consultancy agreement, is to be administered by a service manager. It's absolutely essential for the project that the consultant, however its designated role is labelled, operates these contractual mechanisms and does so correctly. The professional must review all notices that the contractor gives, checking that they are given in time, contain the prescribed information, and comply with any conditions precedent that may be prescribed. It must review and constantly keep under review any entitlements that the contractor may have, including to an extension of time and additional payment. It must also assess impartially and in accordance with the contract. The consultant, given this role, whether an architect or an engineer, is in control of the contract. So the points which we mentioned in this webinar for our contractor clients can equally apply to the consultant. And to state the obvious, if the consultant doesn't comply with their administration duties, they are at the risk of being negligent. Over to Nadir for a bit more detail.
Thanks, Will. In relation to notices and entitlements, I'll look first at two commonly used and reasonably straightforward consultants' appointments. The RIBA Professional Services Contract 2018 and the ACE Professional Services Agreement 2017. I'll then consider in rather more detail the more complicated procedural construction contracts and consultant appointments seen on major projects. The first question is whether the RIBA and ACE appointments have notice requirements. The answer, perhaps unsurprisingly, is that they do. RIBA clause 3.2.2 requires the architect to inform the client of progress in the performance of the services and, upon becoming aware of any issue that may materially affect the project brief, project programme, construction cost or quality of the project, and any information, decision or action required in mitigation. Similarly, ACE clause 8.2 requires the consultant to inform the client if it appears that the consultant has to carry out any additional work and or suffers disruption in the performance of the services because, amongst other things, the consultant is delayed by others or by events that were not reasonably foreseeable or of other reasons beyond the control of the consultant. Our view is that the wording in both the RIBA and the ACE forms is such that you should give your clients notice in relation to COVID-19 now, rather than waiting for the effects to become even worse. I should flag that the ACE appointment has an additional notice mechanism, an early warning clause, but I'll look at that type of clause a little later, so won't cover it here. The next question is whether you're entitled to an extension of time under the RIBA and ACE forms, and in short, we say the answer is yes. RIBA clause 2.3 states that the client acknowledges that the architect does not warrant compliance with the project programme, which may need to be reviewed for, but not limited to, delays caused by, amongst other things, any other factor that is not the responsibility of the architect under the contract. ACE clause 8.2, which applies in the circumstances we just discussed, additional work or disruption for events not reasonably foreseeable and reasons beyond the control of the consultant, also provides for any relevant adjustment to the programme if required. In both circumstances, we say COVID-19 and the disruption caused by it probably do entitle you to an extension of time. The final question is whether you're entitled to additional payment, and again, we say the answer is yes. RIBA clause 5.5 provides that if the architect is involved in extra work or incurs extra expense for reasons beyond the architect's reasonable control, additional fees shall be calculated on a time basis. Matters in relation to which the architect shall be entitled to additional fees include if the performance of the services is delayed, disrupted, or prolonged. Under ACE, the relevant clause is once again clause 8.2, which under the same circumstances described just now, which again we think do apply here, requires that the client shall make an additional payment to the consultant in respect of the additional work carried out and additional resource employed, and or the disruption suffered. And again, we think that COVID-19 does qualify here to entitle you to additional payments. Moving on now to the more complicated, more procedural, more onerous contracts and appointments, we look at probably the three most common standard forms we see in the UK: FIDIC, NEC and JCT. The mechanisms in these are of course more procedural than those that we've just discussed. The first contractual mechanism that you likely have to operate is a warning provision, assuming your contract has one. These used to be reasonably rare aside from the NEC early warning provision, but they've become more and more popular in both standard form construction contracts and consultancy appointments. You'll need to consider carefully in what circumstances your contract requires you to give a warning. These are usually well defined, as well as looking at the consequences of failing to do so, which are often less well defined. I should point out that almost all warning provisions are prospective or forward-looking. In other words, they require you to give warnings as soon as you think something is likely to have an impact. You shouldn't wait until the impact is actually felt. This may be too late. In our view, the present COVID-19 situation in the UK and indeed around the world has developed far enough that it merits a warning under all major standard form contracts and appointments at the present time. If you haven't given a warning under your contract already where there is a requirement, you most likely should have done. We don't think you should wait for delays or cost overruns to actually occur, or for your employer to give you instructions or to suspend work. The 2017 versions of the FIDIC Red, Yellow and Silver books, which I describe in this webinar as the FIDIC Rainbow Suite, contain an advance warning provision at clause 8.7. This is new in the 2017 contracts. You won't find it in the 1999 or earlier FIDIC contracts. This requires each party to advise the other of any known or probable future events or circumstances which may adversely affect the work of the contractor's personnel, increase the contract price, and or delay the execution of the works. Similarly, the FIDIC White Book 2017 contains an equivalent provision at clause 4.3. This, again, is new. The 2006 White Book didn't contain an equivalent provision. This requires each party to promptly give notice to the other of any specific actual or probable future events or circumstances which may adversely affect or delay the services or lead to an increase in the cost of the services. We think COVID-19 and its effects fall squarely within both the Rainbow Suite and White Book clauses. Interestingly, FIDIC doesn't prescribe the results of failing to give an advance warning, but it may well be something that your employer will seize upon to resist any claim for additional time or money that you might make. The NEC, ECC and PSC contain early warning provisions that are known and perhaps loved across the industry. The NEC 3 PSC, for example, requires at clause 15.1 that each party notify the other as soon as either becomes aware of any matter which could increase the total of the prices, delay completion, change the accepted programme, delay meeting a key date, or affect the work of the employer, an employer's contractor, or another consultant. The ECC and indeed the NEC 4 provisions are very similar. Again, we can say with some certainty that COVID-19 clearly falls within this provision. Unlike FIDIC, the NEC early warning mechanism does have teeth. Clause 63.5 of the NEC 3 ECC, for example, specifies that if the contractor did not give an early warning when it should have done, the event and the contractor's entitlement is assessed as though it had given the early warning. Effectively, this allows the project manager the benefit of hindsight, and this could operate to reduce the contractor's entitlement. The ACE Professional Services Agreement 2017 also contains an early warning mechanism, perhaps unusually for a contract that's, as we just discussed, otherwise drafted to be straightforward and easy to operate. Clause 4.2 requires the parties to give notice to the other as soon as they become aware of any matter which is likely to affect the provision of the services, including delay and additional costs. Once again, we say this would encompass COVID-19, although, like the FIDIC advanced warning regime, the ACE's early warning provisions do not specify a sanction for failing to comply. Amended standard forms will occasionally make warning regimes more prescriptive or impose specific timetables for notification. However, warning regimes are rare under bespoke contracts and appointments, save perhaps for those on very big major infrastructure projects. I should point out for completeness that all the warning regimes I've considered place the onus on both parties to notify. But the reality is that the effect of failing to do so, even if there is no prescribed sanction, will typically fall to a greater degree on the contractor or consultant than on the employer. The next contractual mechanism that will become relevant after a warning provision will relate to giving notices of delay and additional cost and making claims. Will touched on these briefly a few slides ago, and under the contracts we're now considering, it's absolutely essential to give notices correctly. The FIDIC Rainbow Suite contains very prescriptive wording in relation to contractors' claims. Clause 20.1 of the 1999 Red Book, for example, states that if the contractor considers himself to be entitled to any extension of the time for completion and/or any additional payment, he shall give notice to the engineer describing the event or circumstance giving rise to the claim. The notice shall be given as soon as practicable and not later than 28 days after the contractor became aware or should have become aware of the event or circumstance. If, therefore, you consider that COVID-19 has triggered an entitlement you may have to additional time or money, and I'll discuss entitlements later in this webinar, you must give notice under clause 20.1 as soon as possible. Unlike the warning provisions just discussed, however, the claims provision isn't prospective. It should be triggered only when you consider that your entitlement has arisen. The consequences of failing to give notice of a contractor's claim when you should have done will be severe. Clause 20.1 goes on to state that if the contractor fails to give notice of a claim within such a period of 28 days, the time for completion shall not be extended, the contractor shall not be entitled to additional payment, and the employer shall be discharged from all liability in connection with the claim. Serious consequences. There are additional requirements under FIDIC once the claim has been made. For example, you must send a fully detailed claim within 42 days of becoming aware of the event. You must send further claims monthly, and you must then send a final claim 28 days after the effects of the event cease. The FIDIC White Book contains similar provisions in relation to changed circumstances, that's clause 4.5 of the 2006 White Book, and exceptional events, that's clause 4.6 of the 2017 White Book. The latter, for example, the 2017 version, requires that if a party is prevented from performing any of its obligations under the agreement by or due to an exceptional event, then it shall give a notice to the other party providing a description of the exceptional event, together with an assessment of its effects on the party's ability to comply with its obligations under the agreement. The notice shall be given within 14 days from when the party becomes aware, or should have become aware, of the event or circumstance constituting an exceptional event. The White Book clause, like the Rainbow Suite clause, kicks in when your performance of the event is prevented, not before. Unlike the Rainbow Suite, however, the White Book doesn't prescribe a sanction for failing to comply with the notice provision, although, of course, it is still very important that you do comply. The NEC contracts and appointments require notice to be given of compensation events. This applies under NEC 3 and NEC 4. It applies to the ECC and to the PSC. NEC 3 ECC clause 61.3, for example, requires that the contractor notifies the project manager of an event which has happened or which he expects to happen as a compensation event, if the contractor believes that the event is a compensation event and the project manager has not notified the effect to the contractor. NEC 3 PSC clause 61.3 is virtually identical. Unlike the FIDIC claims clause, the NEC compensation event provision is prospective. It requires you to give notice if an event that you believe to be a compensation event has happened or is expected to happen. As a result, it's vital that you notify COVID-19 as a compensation event under your NEC contracts now, rather than waiting for it to have a more substantial impact. Like the FIDIC claims clauses, however, there is a severe sanction prescribed for failing to comply with the NEC compensation event regime. Clause 61.3 goes on to say that if the contractor does not notify a compensation event within 8 weeks of becoming aware of the event, he's not entitled to a change in the prices, the completion date, or a key date, with very few exceptions specified later in the clause. Therefore, you will again lose your entitlement altogether if you don't claim in time. Again, you must submit your notices. The JCT suite of construction contracts also contain notice requirements. Unlike the FIDIC and NEC provisions, JCT contracts split up the notice mechanism into 2 sections. Using the JCT standard building contract with quantities 2016 as an example, clause 227.1 deals with notice of delay. This requires that if and whenever it becomes reasonably apparent that the progress of the works or any section is being or is likely to be delayed, the contractor shall forthwith give notice to the architect, contract administrator of the material circumstances, including the cause or causes of the delay, and shall identify in the notice any event which is, in his opinion, a relevant event. Clause 421.1 deals with notice of loss and expense, requiring that the contractor shall notify the architect contract administrator as soon as the likely effect of a relevant matter on regular progress becomes or should have become reasonably apparent to him. In both cases, there are then further requirements to provide updates. Now, obviously, in reality, a single notice will serve as notice of both delays and of loss and expense. Given that, at the very least, the clause relating to notice of delay is prospective, even if the clause about loss and expense isn't, we think you should proceed to notify COVID-19 as a relevant event, relevant matter, under your JCT contracts now. Unlike the FIDIC and NEC claims and notice clauses, the JCT notice mechanism doesn't prescribe a sanction for failing to give notice. It also doesn't specify long stop timeframes for notices. Clearly, this is positive for contractors, but it should not be taken, needless to say, as a reason to fail to give notice. Again, amended standard forms will often make notice and claim requirements more stringent. They may increase the list of items of which notice must be given. They may expand the information that must be given, reduce timescales for providing information, and they may make more drastic the consequences of failing to comply. Bespoke contract and appointments also sometimes contain stringent notice or claim requirements. particularly those drafted by developers. In relation to warning and notice provisions, or I should say, in addition to warning and notice provisions, a number of contracts and appointments also have underlying update provisions, which require the contractor or consultant to provide updates in relation to often site progress in the programme, sometimes the budget, and occasionally also other matters. Consistent with the main theme of this webinar, these must be complied with. These updates may be required periodically, for example, a requirement to issue monthly progress reports, or they may be triggered by particular events, for example, falling behind the programme. Unlike warning and notice provisions, most standard forms don't prescribe sanctions for failing to comply with update requirements, but a failure to comply would of course be a breach, and it could be seized upon by your employer to deny you an entitlement or to claim against you. I'll only mention update provisions briefly. They are part of the underlying contractual mechanism, and you should have been operating them throughout the life of the contract, irrespective of COVID-19. However, it will be essential to see that you do comply with any such requirements that you are subject to, and that you now fully incorporate into your updates the impact of COVID-19 and its effects on your projects. FIDIC contracts contain two separate sets of update requirements. All FIDIC contracts, the Rainbow Suite, as well as the White Book, the 2017 and 99 versions, the 2006 White Book, require revised programs to be issued whenever actual progress is inconsistent with scheduled progress or with your obligations. See, for example, clause 8.3 of the 1999 Red Book or clause 4.3 of the 2017 White Book. Any delays caused by COVID-19 will trigger these requirements. In addition, the Rainbow Suite, that's the 2017, 99 and previous versions of the Rainbow Suite, require monthly progress reports. See, for example, clause 4.21 of the 1999 Red Book. The FIDIC provision relating to progress reports is extremely detailed and very prescriptive. It requires, amongst other things, progress charts, site photographs, safety statistics. The effects of COVID-19 must be fully accounted for in these reports. The NEC contracts, that's NEC3 and NEC4, ECC and PSC, require revised programs to be issued periodically at the interval stated in the contract data. See, for example, NEC3 ECC clause 32.2. The NEC clauses about revised programs are significantly less prescriptive than the FIDIC clauses about progress reports, but they do require statements of actual progress, the effects of compensation events, how the contractor or consultant intends to deal with delays, and any other changes proposed to the programme. Again, it's important that you take into account the effects of COVID-19 when you issue these programmes. We typically advise on NEC projects that the accepted programme goes to the heart of the contract. It is your baseline for assessing a compensation event. If there has been delay and your programme is not up to date, your assessment for a compensation event will be based on an out-of-date version, which in theory means you won't get the extension of time that you deserve or require. JCT construction contracts are brief in this regard. They do not contain standalone update requirements, and there is no programme drafting. Rather, update requirements are triggered by notices of delay and indeed of loss and expense. Using again the standard building contract with quantities 2016 as an example, clause 227.3 and 421.3 require the contractor's assessments of delay and of loss and expense respectively to be updated as and when they change. Once you have issued notices relating to COVID-19 under JCT contracts, it will be important that you comply with these clauses, but in the JCT suite at least, they will not be relevant before you do issue these notices. Standard forms are occasionally amended to make update requirements more stringent, and equivalent requirements are sometimes found in bespoke contract and appointments drafted by developers, but overly stringent requirements are unusual. We've now spoken at some length about the likely effects of COVID-19 on you and on your projects, and about safeguarding your position by operating the contractual mechanisms giving notice of these effects to your employer. However, possibly the single most crucial question for you as a contractor or a consultant will be whether you are entitled to any relief because of COVID-19. Are you entitled to an extension of time? Are you entitled to payment of any loss and expense? This is an absolutely vital question. I'll now look at this question under the major standard form contracts. In general, our view is that under most construction contracts, you will be entitled to an extension of time, but may not be entitled to additional payment. Consultancy appointments may be more generous. However, as always, this depends very heavily on the exact contractual wording. Under the FIDIC Rainbow Suite, employers' risks, as defined in clause 17.3, indisputably entitle the contractor to both time and money. Under the unamended contracts, however, and this is the 2017, 99 and previous versions, we don't consider that COVID-19 constitutes an employer's risk. Although it's always worth checking for any amendments, we often see contracts for projects in the developing world that cite disease, epidemic and pandemic as employers' risks. The outbreaks of Ebola and the like have resulted in this drafting being a reasonably common amendment. An extension of the time for completion will be available using clause 8.4 of the 1999 Red Book as an example, if and to the extent that completion is or will be delayed by unforeseeable shortages in the availability of personnel or goods caused by epidemic or governmental actions. If COVID-19 and its effects do cause shortages, then you will be entitled to an extension of time. An extension will also be available due to any delay, impediment or prevention caused by or attributable to the employer, the employer's personnel, or the employer's other contractors on the site. Unsurprisingly, therefore, if your employer closes the site or implements restrictions that severely impact your ability to carry out work, you will be entitled to an extension of time. Under unamended FIDIC Rainbow Suite contracts, you will not have a general entitlement to an extension of time other than in these two specific circumstances. Although the first, shortages, seems very likely to apply at present and should be quite helpful. Your entitlement to payment of additional cost and expense, by contrast, will depend on the nature of the contract. If you're working under a simple Red Book measurement contract, your employer will likely take the risk of cost increases. However, if you're operating under a fixed price Silver Book contract, you're likely out of luck, although at least you should be able to operate the extension of time regime to get relief from liquidated damages. Under the FIDIC White Book 2017 and 2006, we think you probably will be entitled to both an extension of time and to payment of additional cost. COVID-19 and its effects are likely to constitute an exceptional event under the 2017 White Book and a changed circumstance under the 2006 version. In each case, this entitles the consultant to both an extension of time and to payment of additional cost. Under NEC contracts, that's NEC 3 and 4, ECC and PSC, employers' risks as defined in clause 8.1, again entitled the contractor to both time and money. As with the FIDIC Rainbow Suite, however, we consider that under the unamended contract, COVID-19 is unlikely to constitute an employer's risk, although, again, it's worth checking for any amendments. However, under the NEC contract, COVID-19 is likely to constitute a compensation event. The unamended versions of these contracts contain a catch-all that is very helpful to contractors and consultants. Clause 60.119 of the NEC 3 ECC, for example, states that an event is a compensation event that stops the contractor completing the works by the date shown on the accepted programme and which neither party could prevent, and an experienced contractor would have judged at the contract date to have such a small chance of occurring that it would have been unreasonable for him to have allowed for it. We think COVID-19 clearly falls within this clause. I should say that this clause is often deleted by employers, perhaps unsurprisingly, but even if this is the case, there are other compensation events defined in the standard NEC wording that will also apply in the present situation, such as instructed suspensions, site closures, and failures of others. Compensation events entitle the contractor or consultant to both an extension of time and to additional payment. See, for example, NEC 3 ECC clause 63 and PSC clause 65. Under the JCT contract, entitlements to time and money are separated out. You will be entitled to an extension of time by reason of a relevant event and to loss and expense by reason of a relevant matter. Under the unamended JCT wording, it is debatable whether COVID-19 and its effects are a relevant matter entitling you to an extension of time. Again, using the Standard Building Contract of Quantities 2016 as an example, clause 229 provides that if it is classified as force majeure, or if exercise of a statutory power by the government directly affects the works, then it will be a relevant matter. However, this could be difficult to show. Force majeure is not a term defined in JCT contracts or at common law. More on that in a second. It is also questionable at what point the government exercises a statutory power or when this directly affects the works. It seems unlikely that the Prime Minister's announcements on television or Twitter would qualify. The position is clearer if a suspension is instructed or if the site closes or others fail to comply. These probably are relevant matters. The position is also clearer in relation to loss and expense. We think that COVID-19 does not fall under clause 4.22, so you will not be entitled to payment of loss and expense. However, again, if a suspension is instructed or if the site closes, this probably does constitute a relevant matter entitling you to loss and expense. One of the points Will made towards the beginning of this webinar is that a number of contractors seem to be carrying on work until their employers give them clear instructions to suspend. This will be why. Most UK construction contracts are JCT contracts, and as I've just demonstrated, entitlements to both time and money under these are very unclear in the absence of express instructions. The reason contractors are hanging on, therefore, is to protect their entitlements. As always, standard form contracts and appointments are very often amended to make them more restrictive, and the NEC wording in particular, as I've said, is commonly seen as overly generous to consultants and contractors. The position on additional time and money is very often even more restrictive under bespoke contracts and appointments. There may simply be no contractual entitlement to either, say in the event of an instructed variation or a suspension. Check, however, for circumstances outside the control of the contractor or consultant wording. This is found in some consultancy appointments in particular, and it could prove invaluable. If you can't claim additional time and money under your contractual mechanisms, the next question is whether you can at least seek relief from employers' claims, including for liquidated damages, by raising force majeure. Force majeure is, broadly speaking, a civil law concept. There is no common law doctrine of force majeure in the UK. What this means is that force majeure will only be recognised and given effect to when explicitly written into a contract. This is important. The position on force majeure varies widely between standard forms, but broadly speaking, we think that COVID-19 is likely to constitute force majeure under the most widely used standard forms. Bespoke forms, by contrast, often will not contain any force majeure provisions at all. The FIDIC Rainbow Suite, and that's 2017, 99 and earlier, contain very detailed force majeure provisions. Clause 19.1 of the 1999 Red Book, for example, states that force majeure is an exceptional event or circumstance which is beyond a party's control, which such party could not reasonably have provided against before entering into the contract, and which, having arisen, such party could not reasonably have avoided or overcome, and which is not substantially attributable to the other party. A non-exhaustive list of examples of force majeure is then given, and although disease and epidemic are not set out in that list, we think that COVID-19 and its effects clearly do constitute force majeure. You will be entitled to an extension of time for any delay you suffer by reason of COVID-19, but you probably will not be entitled to payment of any additional cost under clause 19.4. The FIDIC White Book 2017 and 2006 contain wording relating to exceptional events and changed circumstances respectively. These seem broadly equivalent to the concept of force majeure. I ran through these briefly when discussing entitlements to time and cost, and as discussed, we think the White Book does entitle you to both time and money due to COVID-19. As we've mentioned, the NEC contracts contain brief prevention provisions that seem broadly equivalent to force majeure. Clause 19.1 of the NEC 3 ECC, for example, relates to an event that stops the contractor completing the works by the date shown on the accepted programme, and which neither party could prevent, and an experienced contractor would have judged at the contract date to have such a small chance of occurring that it would have been unreasonable for him to have allowed for it. The position is very similar under the PSC and indeed under NEC 4 contracts. In our view, COVID-19 does meet this test. However, unlike FIDIC, the NEC contracts do not state the effect of prevention on the parties' contractual requirements or whether additional time or cost is to be awarded. They state only that the project manager or service manager is to give an instruction. This means that you should be engaging with your project managers and service managers to obtain an instruction as to how to proceed, setting out the risks and parameters you're working under by reference to early warning notices and compensation events, for example. As noted, if you feel there should be suspension, tell the project manager or service manager. As discussed in relation to entitlements, force majeure is a relevant event under the JCT contract, but not a relevant matter. That means it entitles the contractor to an extension of time, but not to payment of loss and expense. Unhelpfully, though, force majeure is not a term that is defined in the JCT contract. As a result, it will be given its natural meaning, which is difficult to discern given that force majeure is not a common law concept. I'll discuss this on the next slide. It is possible, but reasonably uncommon, for force majeure provisions contained in standard form contracts and appointments to be amended. They can sometimes be narrowed or additional restrictions on relying on them inserted. Bespoke contracts and appointments generally do not contain force majeure provisions unless they've been specifically negotiated in by the parties, which you will often see for substantial or high-risk projects, and indeed for projects outside the UK. Check again, however, for circumstances outside the control of the contractor or consultant wording, particularly in consultancy appointments. If there is no force majeure provision in your contractor appointment and there is no such wording, then you may have to rely on common law doctrines. As mentioned on the previous slide, there is no common law concept of force majeure. It's a civil law concept. It'll be given effect to if specifically written into a contract, but it will not otherwise be implied by English law. There are, however, two doctrines that may be relevant in the present circumstance: prevention and frustration. Prevention is a reasonably straightforward doctrine. If your employer causes delay and thereby prevents you from performing your obligations in the time required by your contract, then your employer cannot enforce these contractual timescales against you. In other words, your employer cannot benefit from the result of its own wrongdoing. Prevention will be relevant if your employer closes your project site or issues you with an instruction to suspend. It could also be relevant if your employer imposes measures, for example, restrictions on working methods such as personal separation, that make your work inefficient. The result of an act of prevention is that you will not be held to your contractual timescales, but rather you will have a reasonable time to complete your works. Time will be at large. Many standard form and bespoke consultancy appointments have extension of time regimes that provide that notification within a certain period is a condition precedent. And the reason for this is as follows: if there was no extension of time regime at all, the prevention principle would apply. So providing this extension of time regime with a strict notification requirement actually protects the employer. In this respect, using the NEC3 PSC as an example, note the distinction between the treatment of compensation events arising from an employer's instruction, which do not specify notification within a certain time as a condition precedent under clause 61.1, and compare that with other compensation events which do specify that notification within 8 weeks is a condition precedent under clause 61.3. Prevention, we should point out, will entitle a consultant only to an extension of time, not to payment of additional cost. Frustration, on the other hand, is a more fundamental issue. Frustration is where a supervening event occurs after a contract has been formed that is neither party's fault, but that goes to the root of the contract or affects the contract in a fundamental way and makes performance of the contract impossible, illegal, or unjust. Frustration could apply if, for example, the government requires by law that your construction site closes down for an extended period. A non-mandatory guidance probably wouldn't suffice, neither would a 3 or 4 week suspension. Frustration is a drastic remedy. It operates to discharge all obligations that fall to be performed from the date of the frustrating event. In other words, it operates to bring your contract to an end. For that reason, it's a rare circumstance in which a party will seek to argue that its contract has been frustrated. There are other, far less severe measures that you will almost certainly have in your contract and at law before you get to this stage. But it's important to keep this at the back of your mind as a potential measure. And now back to Will.
Thank you, Nadir. With all that in mind, this slide has some reasonably common sense practical advice for project management. First and foremost, if there's one takeaway from this webinar, it is that you must operate your contract. Issue any warnings, give any notices, make any claims that you're required to do. Do so in good time and give all the information you should give. Keep updating programs, budgets, reports, and anything else you need to update, including updating your warnings, notices, and claims. Always comply with the contract, even during periods of suspension on site. Keep your remedies under review. For every individual event, excuse me, that occurs on site, consider carefully whether it entitles you to an extension of time, to cost and expense, or otherwise to make a claim against your employer. Assess all events separately, don't lump them all together. Aside from giving formal notices, keep communicating with all project parties, with your employer, with your supply chain, subcontractors, subconsultants, suppliers, and with anyone else. Check their ability to perform and their intentions. Can they and will they carry on working? Let them know your position. If you are a contractor worried about whether to carry on, engage with your employer and supply chain to discuss the risks arising, including whether, for example, you can comply with public health guidelines, and if possible, agree whether to stay on site or not. Dialogue in these circumstances are vital. And most important, make sure that you safeguard your personnel, your employees, your subcontractors, and the rest of your supply chain. To the extent that you are able to do so, mitigate the impact of COVID-19 on your projects. And in doing all of this, I say again, follow government and industry guidance. The position is extremely fluid at the moment. With all of the foregoing in mind, therefore, we think that a sensible game plan for carrying out work is as follows. The first question is whether your employer has closed the site or suspended work. If it has, then your position is reasonably straightforward. Stand down, comply with any instructions, consider your entitlements, and give any contractual notices you should give. Continue giving them during this suspension. If it has not, however, then the position is more difficult. We think that if you haven't been issued with a formal notice of suspension, you should stay on site if you can. And you should continue to work if you can do so safely and without imposing risks on your personnel. The reason that a number of contractors are continuing to carry on work is that under the JCT contracts, they are not entitled to additional payment in the absence of a clear instruction from their employers, as Nadir has just mentioned. This may seem a Mexican standoff. Unfortunately, it's just a consequence of the way in which the contracts are drafted. If you are considering remaining on site and carrying on working, your first priority must be health and safety, as we've said. Do you have any concerns about the health and safety position? Are measures to contain COVID-19 not possible to implement on the site? Or are they not being implemented on the site? Is there a risk of exposure to the disease? If so, then you should stop work. Make sure again that you give any notices that you're required to give, and that you state clearly that you are suspending work due to serious concerns around the health, safety, and welfare of your personnel. State what these concerns are. There may be a claim against you. After all, your contract probably requires you to carry on working regularly and diligently, but legitimate health and safety concerns are typically a good defence to a claim, and you would be very unlucky if your employer succeeded in a claim where you stopped working because you had reasonable concerns about COVID-19 and the risk it posed to your personnel. If not, and you don't consider that there's an immediate need to stop work, then consider whether you can follow government and industry guidelines if you continue to work. If you can, then you may consider it sensible to continue working, provided that you do in fact follow these guidance. These include guidance from Public Health England, the note from the Construction Leadership Council, and anything else that may be relevant. If not, however, then again you should stop work and make clear why, giving any relevant notices. Needless to say, you must keep the above considerations under review. There are very real risks to your employees and their health, safety and well-being, to the project, and ultimately to your reputation as a business. Commercial considerations will clearly also be relevant, as well as legal ones. All of these decisions will be a difficult call, and make sure the appropriate advice is taken. So that draws us to the end of this webinar, and I hope you have found it useful. We would, of course, be very pleased to discuss in depth anything Nadir and I have covered today, and to discuss further any particular issues or concerns that you may have in relation to specific projects. Apologies, we have run on, and we haven't been able to answer all the questions raised. As I touched on at the beginning of this webinar was only the first in a series of webinars that we at Beale & Co will be hosting in relation to COVID-19. We'll shortly be hosting jurisdiction-specific webinars covering issues relevant to the Middle East and Irish markets, which will build on what we've discussed today, and details are on the slide. Please email webinars@beale-law.com if you have not yet received an invitation and wish to join. We'll then host, and I mentioned this at the start, a further practical webinar focusing on issues which are likely to arise in the future as a result of COVID-19, including what happens with site security and who is responsible for this, payment issues, recommendations for stalled projects, including what to do when it comes to resuming works, and disputes. We will circulate invitations in due course. If you do need support on COVID-19 or other project advisory, you may be interested in our in-house lawyer service. Just quickly, this virtual service provides you with access to any member of the contracts and projects advisory team to provide in-house counsel type advice, commercial, frank, direct and rapid advice on your projects. Details are on the slide. Please do contact us if this is of interest. It remains me to say thank you for joining me and Nadir this afternoon. Keep safe and follow your contract. Thank you. Goodbye.